Okay, so our last segment before we're done for the day is on enforcement. Our first speaker is Annie Huston. She's with the District Attorney's Office, and she's been there since 2018. She's currently in the Environmental Crimes Division, where she handles both misdemeanor and felony offenses, including illegal dumping of waste, water pollution, air pollution, and improper disposal of hazardous waste. And I've learned she has a trial tomorrow. So it's all yours.
Thank you. Yes, I have a trial tomorrow, so you'll be my practice for Dyer for tomorrow. So my name's Annie Hudson. I'm an assistant district attorney here in Harris County. And if you followed the news over the summer, the county approved the expansion of our environmental crimes division. And I'm one of the new prosecutors that moved into our division in August. So prior to that, I was in what's known as our trial bureau. That's essentially where the majority of the cases in Harris County are filed through the trial bureau and fall into our different district courts. In that position, I was handling a lot of domestic violence, your aggravated assaults, DWIs, all sorts of crimes that just fall through into our regular trial bureau. And then from within that, environmental crimes is a specialty division that handles air pollution, hazardous waste, improper disposal of hazardous waste, water pollution, and illegal dumping, and other specialty investigations that we do into environmental crimes here in Harris County. But my experience in the environmental division is somewhat short because I'm one of the new prosecutors. So my presentation today is going to focus more on criminal procedure and where environmental crimes fit within that, because that's what I know more of from my background trying crimes in our trial bureau. So, I'm just going to click. What are the differences between civil and criminal enforcement? So with civil enforcement, you have discovery procedures. In a civil case, you're going back and forth with your materials. In a criminal proceeding, we are providing the defense all of the information for our cases that we have filed against the defendants. So when we go into a trial, they have seen everything that we are going to present, and we have seen nothing that they could potentially present. There's no obligation for the defense to turn over to us what they're going to present at trial. There's also a lower burden of proof. The burden of proof in a criminal proceeding, as we all know from watching Law and Order for years and years, is beyond a reasonable doubt, and it is a very high burden. But and a well-practiced, seasoned defense attorney will tell you that it's the highest burden, and they'll show you in the stair steps just how high beyond a reasonable doubt is. But my job as an assistant district attorney is to talk to let 12 citizens of Harris County know that it's not an impossible burden, that we can prove our cases beyond a reasonable doubt, but it is a much higher burden than a civil proceeding. There's no culpable mental state in a civil proceeding as compared to a criminal proceeding. We, depending on how the case is pled, are going to have to prove the intent of the defendant. Consequences, fines versus jail time. When bringing a case before a jury, during jury selection, one of the questions that I'll have to ask is whether or not the juror can consider the entire punishment range. And so for environmental crimes cases, sometimes that will kick people off of your jury because they just couldn't consider jail time for a defendant. No limitations, so every single crime has a punishment range. So towards the end of my presentation, I'm going to go through the various punishment ranges, and then in a civil proceeding, you have injunctive relief. So you can immediately file an injunction, whereas here with a criminal proceeding, it's a more drawn out process, and you're ultimately either resolving the case with a plea or a finding of guilt at trial. Oh. Okay, so with civil penalties, just kind of drawing a distinction between criminal and civil penalties. The civil penalties are divided between state and local governments, and they can also include attorney's fees, investigative fees, and court costs. And they're not confined by the numbers the way that our punishment ranges are. The punishment range is attached to the conduct itself, and we can only resolve our cases within that punishment range. So with a fine, if, say, someone was convicted of illegal dumping, we can only plea them within the punishment range, or the jury could only consider the punishment within that punishment range. So, as I said at the beginning, some of the cases that we prosecute: illegal dumping, which is a strict liability case. What offense? So what that means is, if a defense attorney came to me and said, well, he did commit the offense, there's plenty of evidence that he did, but he just had no idea what he was doing, and that because illegal dumping and misdemeanor water pollution is a strict liability offense, I don't have to prove that he did it intentionally or knowingly. Water pollution intentionally or knowingly becomes a felony offense. Used Oil Act violations, air pollution, and hazardous waste violations. Those are the type of crimes that we prosecute. We're also, there are some other cases where we're beginning to look into using some of our other statutes like reckless assaults, and becoming a little bit more creative with the kind of cases that we can file. But right now, these are predominantly the statutes that we use while filing our cases. Evidence. So when a case is filed, it's either going directly to our intake division, or we're bringing it straight to grand jury, and that's where you're presenting a case and saying that you've established probable cause to charge that defendant with that offense. Prior to that, then, you want to get as much in your cases as possible. Investigative reports from your filing agency. So those are your police reports, the police going out to talking to people, establishing probable cause for search warrants. I'm sure that you've watched Law and Order SVU, and they make it look like you just walk into a room and Olivia Benson says he did it, and all of a sudden we have a search warrant in our hand and can search everything. That's not how it works. The officer would need to describe in an affidavit exactly why he has probable cause to believe that this particular piece of evidence exists in this particular location, such that we have sufficient probable cause to search and seize that piece of evidence. And it's really important in our cases that early on everything be done correctly, and that be a good search warrant, a good affidavit, because further down the line, once someone is charged with a criminal offense and looking at potentially becoming a felon, that affidavit and search warrant will be criticized by their defense attorney, and if there, for one reason or another, there was insufficient probable cause to search that particular piece of evidence, then we lose, that evidence would be suppressed at trial, and we've lost a critical piece of evidence in our criminal proceedings. Photographs, videotapes, especially citizen testimony about problems. When I was trying cases in our trial bureau all the time, you'd get phone calls from witnesses. Can I just give you an affidavit? That does not work. If we're going to put someone in jail, we need people to come down to court and testify to the criminal conduct. And so citizen testimony about the problems that they're experiencing, their health concerns, their medical records, fire marshal testimony about fire hazards, health department testimony about health problems in the area are all pieces of evidence that we try to compile before filing a case in order to meet our burden of beyond a reasonable doubt. So, like I said, in Law and Order SVU, it makes it look like the case is resolved in 40 minutes. That's not the reality. So what happens next? So we've compiled all of that evidence that someone committed an environmental crime in Harris County. Perhaps we see it on the news, perhaps we don't. What happens between then and this bottom one, which is jury trial, which we also see on the news? Well, lots of stuff is happening in the interim. The defendant is arraigned. For misdemeanors, that means that a judge will hear the probable cause in that case. And once the judge finds that there is probable cause that this defendant committed that offense, the case will proceed from there. The defendant is on bond. So when we're talking about environmental crimes cases, it may be something like a high managerial agent in a company, but it's no different than an aggravated assault defendant. They're on bond, they're showing up to court, the criminal procedures are all the same, and so each one of our cases is structured around the Code of Criminal Procedure. So we are each one of these steps, we're following the laws within the Code of Criminal Procedure, even though a lot of the times it can end up kind of looking like a civil proceeding in terms of the discovery that we're getting, and some of the issues in cases like charging a company versus an individual. So this first step is arraignment. The next ones are disposition settings. That's at those disposition settings, those can last for sometimes years in something like a murder trial, and that's where you're exchanging evidence. So, for example, lab reports, 911 calls, statements that people were making on scene, police reports. The second one is Brady information. Brady is one of the most important words that you ever hear as a prosecutor. Brady is a decision that requires a prosecutor to turn over any potentially exculpatory or mitigating evidence within their possession. So what that means is if there is any sort of information, perhaps someone made an inconsistent statement at some point, or say there's a break in the chain of custody or something along those lines, that is Brady information that needs to be turned over to the defense. And it's a very, very serious thing to commit a Brady violation during a criminal proceeding. Subpoena responses, so sending out subpoenas, having responses from agencies, TCEQ, EPA, search warrant results. So I referenced that earlier, drafting search warrants, say for cell phones that were seized, establishing the probable cause for why you believe that there's evidence on those cell phones to prove the criminal offense. And from there, you can end up having pretrial motion settings. So this is where the defendant has a defense attorney who sees issues in our case that he thinks that our case is weak for one reason or another, and he or she's going to bring up an issue, a motion to suppress issue, or potentially a motion to quash. There are all sorts of other pretrial motions that could be filed. Those are just two examples. So, for example, a motion to suppress could be filed prior to the trial date, and the defendant could be saying that affidavit that the officer wrote as the probable cause to search the cell phone that uncovered an email that showed that the CEO sent an email that said that, release it all in the air, something along those lines. If the affidavit was improperly drafted and there wasn't probable cause to search that cell phone, that incriminating piece of evidence would be suppressed at trial. What that means is, it doesn't necessarily mean that we have to dismiss our case, but it would mean that we would have to reevaluate it based on whether or not we can prove the crime absent that piece of evidence. Likewise, a motion to quash is a motion that's filed oftentimes when defense is saying that they've been inadequately put on notice about the crime that they're charged with, such that they could present an adequate defense or protect themselves from double jeopardy. So it's oftentimes if you filed a case against someone and they said, well, I'm going to file a motion to quash because you didn't specify exactly the actions of the defendant such that I could protect myself from future prosecution for this same conduct. And then all in this time period, plea negotiations are happening. So for example, this happens all the time in our cases. You would have, prior to your pretrial motion to suppress, one offer on your case. And you're making offers within your punishment range, obviously, which I referred to earlier. So you would be offering something, okay, well, if we're going to have the motion to suppress, my offer will be different after that motion to suppress. And plea negotiations are constantly going back and forth. They're based on each prosecutor's assigned to that case's evaluation of the case, of the conduct, deterrence, and any sort of mitigating factors potentially about the defendant's background. But what I oftentimes tell victims of cases is that it is a plea negotiation. So while we have a punishment range, we are not going to make an offer, 99% of the time, we're not going to make an offer that's the very end of the punishment range, because there's no incentive for the defendant to plea. If your offer is on a case where the maximum fine is $5,000, you're not going to offer as a plea negotiation $5,000, because then the defendant is like, well, why don't I just roll the dice at trial if you're not willing to reduce the fine potentially. So a lot of plea negotiations is a prosecutor evaluating their case, trying to determine what they could potentially get in punishment if they went to trial, and making those sort of back and forth determinations with the defense. Oftentimes they'll counter and come back to you. And so a large portion of what we do is plea negotiating with the defense prior to that jury trial setting. So I'm going to go into the mental state. So intentionally, intent is defined in the Code of Criminal Procedure as a conscious desire to engage in the conduct or cause the result. And how do we prove intent? So tomorrow when I'm picking my jury, I'll ask, how do we prove intent? What are we looking at? And a lot of the times one of the shticks that people do is walk up to one of the jurors and stick out your hand and say, and shake their hand. And then you say, well, how did you know that I was going to shake your hand? And they say, well, you walked towards me with your hand out, and I knew that that meant that you wanted to shake my hand. So it goes to circumstances, the defendant's actions, reasonable inferences based on the evidence. Because when someone is committing an intentional act, I referred earlier to an email that says, release all of that into the air. It's very rare that you're getting a piece of evidence like that speaking directly to intent. So you're looking at circumstances, the defendant's actions, reasonable inferences based on the evidence to try to establish that the defendant acted with intent. You don't have to prove premeditation, and you don't have to prove motive. Though by presenting that sort of evidence, it is compelling evidence for intent, though you're not required to do it. And then the Code of Criminal Procedure defines recklessness as a person who acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the results will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. So I made them a little bit larger. The portions of this that can be challenging to prove at trial are a substantial and unjustifiable risk that an ordinary person would exercise under constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances. So from a defense perspective, they would potentially look at a reckless case where you're trying to prove the recklessness of the defendant and say, under these particular circumstances, the defendant was not acting recklessly. And it can be very challenging to prove at trial because, as I referred to earlier, you would need to prove beyond a reasonable doubt that under the circumstances, the person disregarded a substantial and unjustifiable risk. And it's not, like I said earlier, it's not that it's an impossible burden to meet, it's just that it can be very challenging. And so when deciding whether or not to file one of these cases, you want to make sure that you have sufficient evidence to meet every single element of proving up the recklessness of the conduct in your case. So in Texas, there are two phases of a trial, of a criminal trial. There's guilt, innocence, and there's punishment. So guilt, innocence is a factual, non-emotional decision based on whether or not you believe beyond a reasonable doubt the defendant did what he or she is charged with. Essentially, have we met the elements to prove that this person committed this offense on this date? It doesn't go into the background, the propensity, the relationships between the various people prior to this, unless that was at issue in the case. That comes in punishment, where once the jury finds the defendant guilty, they can consider all of these other factors. And at that point, the defendant has been convicted of the offense, and then you essentially put on a whole new case. You have a punishment case where you're asking the jury, within the punishment range, we would like you to give the defendant 4 years probation with this amount of a fine, or we want you to give him 2 years in prison, and here's why. Look at all of this evidence of propensity to commit these crimes, committing crimes in the past and not learning the lesson, things like that. That can all come into punishment as evidence, but it's not going to come into guilt, innocence, because just because someone did something in the past, that doesn't necessarily mean that we have sufficient evidence to show that they committed this crime. So that's why it's bifurcated into two different sections. So like I said, I just wanted to go back over this because we talked about strict liability and recklessness and what the standard for intentional is. Illegal dumping is a strict liability case. Water pollution misdemeanor is a strict liability case. Water pollution felonies are intentional or knowing. So when we talked earlier about Harris County pollution controls expansion, that would help us a lot in proving our felony water pollution cases, because it helps us show that this person has been warned. We're creating a record of how many times we've gone out there and asked them to clean up, and they're not doing it. That helps us prove intentional or knowing used oil act violations, air pollution, and hazardous waste violations. So I'm going to go over illegal dumping and water pollution elements. So a person commits illegal dumping when they intentionally or knowingly or recklessly, but the reckless only applies to felony cases, transports litter or other solid waste to a place that's not an approved solid waste site for disposal at the site. So there are three different classes of misdemeanors. You have a Class C, which is only punishable by a fine, tickets. So you have a punishment range that doesn't include time in the Harris County Jail. A Class B misdemeanor is punishable by up to 180 days in jail and up to a $2,000 fine. A Class A misdemeanor is punishable by up to a $4,000 fine and a year in the Harris County Jail. And then, so those are your misdemeanor offenses. Above that, you have your state jail felony offenses, and those are punishable by up to 2 years in a state jail. And then above that are your felony offenses, which are where you get sent to prison. And there's a whole classification of felony offenses. So this type of, so illegal dumping is a Class C misdemeanor depending on the weight. So if the solid waste weighs 5 pounds or less or has a volume of 5 gallons or less, then that means that it's a Class C misdemeanor punishable by a fine. If it's more than 5 pounds but less than 500, or has a volume of more than 5 gallons but less than 100, it's a Class B misdemeanor. And then it becomes a Class A if it weighs 500 pounds or more but less than 1,000, or has a volume of 100 cubic feet or more but less than 200. So when you're looking at these are the elements of the offense. So say I filed one of these cases, I have to prove every single one of these beyond a reasonable doubt. So perhaps I prove to you that Joe Smith committed this illegal dumping. I also have to prove to you beyond a reasonable doubt that it was a solid waste, that it weighs 500 pounds or more, in order for you to find that person guilty of this offense. So while it may look like, oh, I saw that video and I saw him throw something out the window or something along those lines, you would have to prove every single element beyond a reasonable doubt, including the weight or volume. So it becomes a state jail felony to commit an illegal dumping when it weighs 1,000 pounds or more or has a volume of 200 cubic feet or more. And so we're seeing this a lot of times at what are called chronic dump sites, places where people are just placing garbage on the side of the road. And a lot of these cases we make by either someone observing a license plate of the person who's leaving the materials, or by leaving identifying information inside of the waste that they leave. And oftentimes these type of cases, we have a large backlog of them, and we're working through them now. So hopefully, as we're expanding, we're going to be able to do more illegal dumping enforcement, as well as more water pollution, air pollution enforcement going forward. I'm kind of going to go through these pretty quickly. So enhancements are essentially a tool that we are able to use to increase the punishment range because the person has committed an offense in the past, which increases our punishment. So if prior conviction for offense under this section, punishment is increased to the next degree, to the next highest category. So if you committed a Class B previously, if you were found to be illegal dumping again, the next time it's going to be a Class A. And then the next time after that, it's going to be a state jail felony. Dumpster provision. Some people, I'm sure, are completely unaware of this, but within the illegal dumping statute, it is unauthorized to dispose of litter or other solid waste in a dumpster or a similar receptacle of someone that didn't give you permission to use their dumpster. It's just a particular provision within the illegal dumping statute. And then there's also a temporary storage provision that says that if someone's storing the waste material for future disposal on property that's owned by that person, then they can't be charged with illegal dumping. So someone could potentially argue, well, it's just here for now, but I had plans to properly dispose of that, and that's why it's still here. That's provided in the statute as a defense. So that can be one of the issues that we have to evaluate when we're looking at our cases. As I referenced earlier, an offense under this section may be prosecuted without alleging or proving any culpable mental state unless the offense is a state jail felony. So all of that I went into earlier about proving intent, all of that applies to the misdemeanors, but when you've reached the state jail felony, the state would have to prove recklessness. And then there's a commercial purpose presumption. A person who dumps more than 5 pounds or 13 gallons or other solid waste from a commercial vehicle in violation of this subchapter is presumed to be dumping for a commercial purpose. And so commercial purpose dumping for a commercial purpose becomes a state jail felony after after it's over 200 pounds of material. There are affirmative defenses to the illegal dumping. It's an affirmative defense to prosecution. What an affirmative defense is essentially that it becomes the burden of the defendant to prove this at trial, that the storage, processing, or disposal took place on land owned or leased by the defendant who received the litter or other solid waste from another person. The defendant, after exercising due diligence, did not know and reasonably could not have known that litter or other solid waste was involved, and the defendant did not receive directly or indirectly compensation for the receipt, storage, processing, or treatment. So this is just a very detailed affirmative defense that the legislature has carved out of the illegal dumping statute. The solid waste, so it is a somewhat broad definition, in part because we need a broad definition because the stuff that's being dumped on the side of the road is oftentimes, it could be anything, it could be it could be any sort of material, and so that's why we kind of do need a broad solid waste definition, but it has to be defined enough to put the defendant on notice. So solid waste means garbage, rubbish, refuse, sludge from a waste treatment plant, water supply treatment plant, or air pollution control facility, and other discarded material, including solid, liquid, semi-solid, or contained gaseous material resulting from industrial, municipal, commercial, mining, and agricultural operations, and from community and institutional activities. So it's pretty broad. So now going into our water pollution cases, it's out of Chapter 7 of the Texas Water Code, which refers to criminal offenses and penalties. It defines waters of the state of Texas, and as of 2004 in this decision, which came out of Huston, it was a case that our Environmental Crimes Division found. It includes drainage ditches. So if someone is improperly disposing of material and they're, say it's sewage from their home septic tank that they're putting potentially, say, onto their neighbor's property, which is then going into the drainage ditch, they can be charged with water pollution because the case law has set the precedent that the waters of the state covers drainage ditches. Industrial waste means waterborne liquid, gaseous, or solid substances that result from any process of industry, manufacturing, trade, or business. And then this is going back over the definition of waste and as defined within the water code and applicable to our water pollution cases. I'm going to start moving a little bit faster. So the statute defines pollutant as well, and all of these are elements. The reason that I put these in here is because all of these are elements that we would need to prove at trial. So we're proving pollution, we're proving sludge, we're proving pollutant, because when we take a case to trial, we're going to have to present this definition to the jurors and say the state has met its burden of proof in this case. Discharge. So discharge includes to deposit, conduct, drain, emit, allow to steep or otherwise release or dispose of, or to allow, permit, or suffer any of these acts or omissions. So like solid waste, it's a somewhat broad definition, but that's good in that it allows us to look at a wide range of activities when we're assessing whether or not we can meet the elements of a water pollution case. So a person commits the water pollution where they intentionally or knowingly, with respect to conduct, discharges or allows the discharge of a waste or pollutant into or adjacent to waters in the state. So that Watts case was challenging that, whether that adjacent, where exactly that lies, and they've decided that it's a case-by-case analysis that causes or threatens to cause water pollution unless discharged in strict compliance with all required permits. So compliance with permits is excluded from, you can't prosecute someone for a criminal offense where they have received the permits for that pollutant. So potentially what we'll get at trial is a negative certification saying that that was an unpermitted discharge. A person intentionally or knowingly, with respect to conduct, discharges or allows the discharge of a pollutant from a point source. So this one is distinctive in that it's from a point source, so from a pipe, say. And then this is the definition of point source. So I'm going to go really quickly through the punishment ranges for water pollutant because they get really complicated. But for an individual, it's a fine between 1,000 and 100,000, or confinement in a prison not to exceed 5 years. So that's in prison, that's a third-degree felony. And so if someone wanted to take their case to trial, that would mean that they're going to the jury, and the jury would be deciding where within that 1,000 to 100,000, or where within the range of up to 5 years in prison they would want to give the defendant once found guilty. They can also, the jury could also assess probation potentially. For a company, a fine not less than 1,000, not more than 250,000. And then for an individual, these are the other punishment ranges for water pollution, this is another enhancement, which I referred to earlier, where enhancements, they have to be proved up at trial, but they allow us to increase our punishment range. And then I'm going to go really fast through used oil because I'm slow. So the elements of discharge of used oil into water: intentionally discharging used oil into a sewer, a septic tank, or a drainage system, surface water or groundwater, a water course, or marine water, unless concentration is less than 15 parts per million, a person has a storm water permit. So, like I mentioned earlier, it's the state's burden to prove each one of these elements at trial. So what that would mean is I would have to prove intentional discharge into a sewer or a drainage system, and then I would also need to prove that unless the concentration is 15 parts per million, so I would need to prove that it's above 15 parts per million. So that would mean presentation of expert testimony, sampling, and presenting evidence to prove each one of those elements. Knowingly mixing or commingling used oil with solid waste that is to be disposed of in landfills. These are all the different types of disposal of used oil that are criminal offenses. Knowingly transporting, treats, stores, disposes of, recycles, causes to be transported, or otherwise handling any used oil within the state in violation of standards or rules for the management of used oil. So as I mentioned earlier, some of these cases can be really challenging in that you would need to find evidence of knowing transportation, treats, storage of used oil in violation of the standards. So when the burden is as high as beyond a reasonable doubt, proving that knowing element can be challenging. And then intentionally applying used oil to roads or land for dust suppression, weed abatement, or other similar uses that introduce used oil into the environment is punishable by a punishment range between $1,000 and $50,000, or imprisonment not to exceed 5 years. And then for a corporation, it's a fine not to exceed $20,000 or a fine not to exceed $50,000 if the individual suffers serious bodily injury or death. In some respects, these can be somewhat antiquated statutes, but we are confined by the language of the statute. So if we can prove the offense, that's the punishment range that the offense allows for. Or a fine not to exceed double the amount gained or caused by the corporation or association to be lost or damaged, whichever is greater, if a court finds that the corporation or association gained money or property or caused personal injury or death as a result of the criminal offense. So as I referenced at the very beginning, in some ways it's civil proceedings have more in that they can more leverage in that they aren't confined by the punishment ranges in the same way that our criminal proceedings are. So that's the end of my presentation. Does anyone have any questions? Okay.
I had a question about what you were saying earlier about using reckless assault. Is that something you could talk about?
Yeah, I mean, it's something that in our office has filed a case right now against Arkema, and I can't talk about it too much because it's still pending, but it is filed as a reckless assault. And so the idea is that if I go back to the definition of reckless, so that someone disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. And then the definition of an assault is causing pain or bodily injury. And usually we only file our intentional assaults. So say you went to a bar and someone punched you in the face, we're going to file that assault. Say you go to a bar and someone throws a beer bottle on the ground and a piece of it hits your leg and it causes you pain. We're usually not filing those, though it is we could. And so reckless assault is sort of in that same regard. It's the idea that you would be filing a case where someone has disregarded a substantial and unjustifiable risk such that they've caused harm to another person, caused them pain or bodily injury. And a reckless assault is a Class A misdemeanor. So in order to make it a felony, you would need to prove that it was a reckless assault of a public servant. Any other questions? Okay, thank you guys.